I hear some.
Good morning.
State of Michigan, Detroit 36th District is now in session. The Honorable Judge Aliyah Sabree presiding. Good morning, Your Honor.
Good morning, everybody.
Good morning, Judge.
Good morning.
We're gonna start with Mr. McLaughlin, Leonard McLaughlin.
Ready, Your Honor.
This is case 2259014, the people of the state of Michigan versus Leonard Norwell McLaughlin. Charged with count 1, police officer assaulting, resisting, and obstructing, count 2, police officer assaulting, resisting, and obstructing, and 2 misdemeanors, assault or assault and battery. Set for exam yesterday, adjourned to today. Appearances?
Alexander Kirker on behalf of the people, P86282.
Bob Zaranick for Mr. McLaughlin, Your Honor, P39346. Can you state your name, sir?
Leonard McLaughlin.
Mr. McLaughlin, state your name one more time, I didn't hear you.
Leonard McLaughlin.
Thank you, good morning.
Good morning.
And attorney, is it correct that your client wishes to waive his exam?
That's correct, Your Honor. Thank you.
Okay. Any objection from the people?
No objection.
Okay, Mr. McLaughlin, I'm going to ask you a series of questions. If you don't understand my questions, please let me know. Also, if you cannot hear me, let me know. Understood?
Hello?
Mr. McLaughlin is who I'm talking to. We're on the record, sir.
Yes.
Can you hear
Hello?
me, Mr. McLaughlin?
Yes.
Okay, I'm going to ask you questions. If you can't hear me or if you can't understand, please let me know. Okay?
Okay.
Is it your wish to waive your exam today?
Yes.
You understand you have a right to a preliminary exam?
Yes.
And that if you were to demand that exam, the people will have to show that the probable cause standard, which is a much lower standard in criminal law, but still a standard, that those crimes that I read, those charges I read off in the information were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
And that by waiving your exam today, that means the people do not have to prove any of that today. You understand that?
Yes.
Did anyone force you to waive your exam today?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given, Mr. McLaughlin. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information on May 2nd, exactly 2 weeks from today. Mr. McLaughlin and Attorney Zaranick, do I have both of your permission to sign the waiver form since you all are on Zoom?
Yes, Your Honor.
Yes.
Okay, anything else? Judge, you didn't give a time.
We had an exam date set for judge for 4/28. I guess we don't need that.
Okay, we'll take it off the docket. And also, it's at 9 o'clock for
Good morning.
Thank you.
Okay.
Okay, you're all set, Mr. McLaughlin. Have a good one, Attorney Zaranick.
Thanks, Judge. Have a
Sure.
great day. Take care.
You too. Yeah. Thank you. Forgot. Okay, McLaughlin, I filled it out yesterday. Okay. Roberts, good morning.
Dan,
Good morning, Your Honor. How are you?
I'm fine, how are you
Dan,
doing?
I'm doing well, thank you.
You got today?
Yeah.
I am here on Mr. Jovan Reed. I have not gotten a call back from Mr. Reed, so I'm fine just waiting on the Zoom, and if needed, just getting a brief adjournment. This is the first time probable cause conference.
Okay, I will have you checked in and waiting on Mr. Roberts.
Thank you.
You're welcome. For all defense counsel looking for an exam date, I am sending in the chat now available dates. So if your case is not called next, could you please look at those dates to expedite our hearing? Attorney
Your Honor,
Jefferson?
this is Attorney Jefferson. I have Ardell Harrison. I think I want to competency and criminal responsibility.
No set for a PCC.
I realize
What did you say you needed?
competency and criminal responsibility. Mr. Ardell keeps picking up cases whilst he's locked up, the same case.
Attorney Jefferson, did you say you wanted a referral?
Yes,
Okay, is he said he's in custody?
yes.
Okay, well, he's not on the screen as of yet. To the individual in Division 1, 8th floor, can you unmute the device and state your name, please?
Ronnie Johnson.
Ronnie Johnson, is there anyone present representing Mr. Ronnie Johnson? Okay, Mr. Johnson, I have you check if you're looking present. Attorney Payne, good morning.
Good morning, Your Honor. How are you?
I'm fine. How are you doing?
Good, thank you.
Who do you have today?
I have Janelle Ponder. She is in the Wayne County Jail.
Okay, all right. We need to get this attorney Bates on. Okay.
John Sabree.
Good morning. One moment. A.G. Peterson,
Good morning. I'm here with Tamika Christian.
Hello.
Christian. Okay,
Thank you.
I have you checked in. Christian. Wait, I don't see a Christian on the docket today. You said Tamika Christian?
Yeah, this was, I believe, set for her PCC.
I don't have Tamika Christian on the docket. Do you have a case number?
I will, 1 second.
Attorney Payne, I can have your message as well.
Hello.
Yes, can you stop saying hello, please?
Morning. Who's working today? Supposed to be.
You check, thank you. She says I'm sitting in your house. She said for Tamika Christian. We don't have Tamika Christian.
Did they ever come back to the case number, Your Honor?
Yeah.
Okay. That case is in front of you on 424 at 1:30. Okay. I'm sorry, I didn't catch for Tamika Christian, the attorney for Tamika Christian.
Good morning.
Oh, I have that set on Judge Sabree's docket for April 24th at 1:30.
Oh, that's the exam date, correct?
Yes, ma'am.
Okay, thank you.
You're welcome. Thank you.
Your Honor, I'm gonna change devices.
Okay, Attorney Riggins, good morning.
Good morning, Your Honor. I'm here on Charles Thomas with Jeffrey Konecki.
Is Mr. Thomas present?
I don't see.
Yeah, good morning. This is me in the blue.
Okay, morning, sir. call Mr. Thomas. This is case 2356122, the people of the state of Michigan versus Charles Lee Thomas. Mr. Thomas is charged with 1 count of robbery armed set for a PCC today. Appearances?
Alexander Kirker on behalf of the people, 886-282. May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800 on behalf of Mr. Thomas.
And good morning, Your Honor. Good morning to your staff, Neighborhood Defender Services by Ken Riggins, 2125 on behalf of Mr. Charles Thomas.
Can you state your P number one more time?
Sure, 82125.
Thank you. And Mr. Thomas, can you state your full name for the record, please?
Charles Lee Thomas.
Good morning to everybody. I believe we have an exam date scheduled already, so today was to visit to discuss discovery, is that correct?
Yes, Your Honor.
Has anything been resolved?
No, Your Honor, we still have not received any digital discovery. I checked with my team administrator and the general person that handles kind of the discovery and everything. They searched through and found nothing more than what we already have. Unfortunately, because the complainant in the case's statement, the only statement that he gave is only on video. We really do need this discovery before we can go forward. And we still do not have any digital discovery in our possession. We have reached out to the officer in charge and have not heard back yet.
Okay, I will sign a discovery order today. And you all want to come back in a few days or just wait for the exam and motion if you don't have it on the day of discovery or the day of the exam?
I mean, Your Honor, if we could maybe come back Friday and see kind of where we're at, that'd give us then, if we need to put together a motion because we haven't gotten anything, it'll give us some time before the exam to get it in.
Okay. I'm going to be absent for our holiday on Friday.
Okay.
It'll be a different judge. Unless you all can log in at exactly 8:30, I can handle your case first. I have to be somewhere at 9 o'clock.
I can be on at 8:30 right away, Judge, if that's okay. Easiest. If something happens, then you can't, Judge. We understand. We'll still get it handled.
Okay, I'll do Friday at 8:30.
Thank you, Your Honor.
You're welcome. You're all set, Mr. Thomas, for today.
Thank you.
You're welcome. Ready on Trice?
I'm ready, Judge.
People of the state of Michigan versus Malik Jamal Trice, case number 230560891. Mr. Trice is charged with 1 count of carrying a concealed weapon. Set for a probable cause conference today. Appearances?
Alexander Kirker on behalf of the people, P86282.
And good morning, Emily Elijah, P85039. I'm standing in on behalf of Jackie Pilkowitz, the attorney of record for Malik Trice. I'd ask the court to waive his presence. Ms. Pilkowitz appears to have very good communication with the client, and I'm just asking to set for an exam today.
Okay, I will waive his presence. Did you look at the dates provided?
I did, Judge, and it looks like May 1st, 2nd, or 3rd would work for Ms. Pilkowitz.
Okay. Let's do May, you said May 2nd or 3rd? First,
yes.
2nd, or 3rd? Okay, let's do May 3rd at 10 o'clock.
All right.
Okay, anything else?
No, Judge, thank you.
You're welcome. Have a good day.
You too. Thank you so much.
You're welcome. Attorney Prempeh, are you ready on your case?
Yes, Your Honor. Good morning.
Good morning. This is case 2356342, people of the state of Michigan versus Jim Brown, who's charged with 1 count of police officer assaulting, resisting, and obstructing set for a probable cause conference today.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Jabari Prempeh, P81745 on behalf of Mr. Jim Brown, who is not present, and respectfully, I'm requesting a waiver for his appearance.
Okay, I will waive his appearance. Have you been in contact with him?
Yes, Your Honor. In fact, he's supposed to be, I guess, on a bus for some reason on his way to the courthouse. But I did speak with him. He was having some issues with Zoom.
Okay. Do you have discovery?
I do have discovery, Your Honor. We are looking for a preliminary examination date, but I did want to discuss his bond conditions, if possible.
Okay. What day did you pick?
I'm sorry, I wasn't aware of dates to pick from.
Okay, I'll resend it.
You're sending an email?
No, it's in the chat. I'll resend it.
Oh. Oh, okay. Oh, all right. May 2nd, Your Honor.
Okay. I have 1:30. That's it.
Oh, whoa. I'm sorry. Can we do May 3rd at 10:30?
May 3rd, 10:30. Okay, and you want to address bond?
Yes, Your Honor. Particularly my client's house arrest condition. He has a job. He works as a mason, and of course, house arrest doesn't allow him to make any money to support himself. Respectfully requesting just to lift that condition so that he can go back to work.
Anything from the people?
People leave it to the discretion of the court.
Okay, I will remove the house arrest restriction. He's still on a tether, and it's curfew. Does he has employment or he's looking for employment?
He has employment.
Okay. Do you know his hours by any chance?
Not offhand, Your Honor. I do not. My apologies.
Okay. Can you contact your client at some point today and get back with the court because I do want to put a curfew on as long as he's not working a night shift.
I say I will do, Your Honor.
Okay, but I will lift the house arrest.
Thank you.
You're welcome. Anything else?
Nothing else, Your Honor. Have a wonderful day.
Thank you. Okay, Attorney Bates, good morning.
Good morning, Your Honor.
Ready on Mr. Ronnie Johnson?
Yes, I am.
Okay. Where they coming? Ready to go? Yes. This is the people of the state of Michigan versus Ronnie Johnson, 2356246. Mr. Johnson is charged with 1 count of police officer assaulting, resisting, and obstructing, and also a misdemeanor refusal fingerprinting with the habitual offender third offense notice set for a probable cause conference today. Appearances.
Give a fuck. On behalf of the people, P86282.
And good morning, Your Honor. Melanie Bates, P76080, appearing on behalf of Mr. Ronnie Johnson Jr., who is present via Zoom through the Wayne County Jail.
And Mr. Johnson, can you state your full name for the record, please?
Ronnie Johnson.
Good morning. Okay, Attorney Bates, I am sending in the chat the available dates for an exam. Let me know what dates work for you. I guess I should ask first, do you have discovery?
Yes, Your Honor, I just got discovery. I need to review that with Mr. Johnson.
Okay, and I just sent in the chat to everyone the dates available.
Okay.
Mr. Phillips, are you in the wrong courtroom?
Me?
Your name is Mr. Phemister?
Yeah.
Phemister? Okay, you should be in.
Is this Sabree?
Yes.
I don't think so. This is
Okay,
the courtroom they told me to join.
Okay. Did you pick a date, Attorney Bates?
Yes, Your Honor, May 1st at 1:30 will work.
Okay. May 1st at 1:30. And Mr. Johnson, your preliminary examination has been scheduled for May 1st at 1:30. in person at 36 District Court. Anything else from either party?
I know. Thank you. Hey, real quick, can I tell my lawyer real quick?
Yes, I can put you on to a breakout room.
Yeah, I think. You can do it.
Mr. Dempster, you're right. You're in the right courtroom. I have you checked in. Attorney Brown, I messaged you to see if you were ready. Are you ready on your case?
Oh, yes, I'm ready.
Okay. And if you're laying down and in court, could you please sit up, please? Ms. Eileen Fong, can you please sit up your court still? This is case 2356134, the people of the state of Michigan versus Sandra Shanice Blackton, who is charged with one count of weapons carrying concealed separate probable cause conference day. Appearances?
Alexander Kirk on behalf of the people, P86282.
And Brian Brown, P80560, appearing on behalf of Ms. Sandra Blackton, who is present. Ms. Blackton, please state your name for the record.
Good morning, Sandra Blackton.
Okay, Attorney Brown, do you have discovery?
Yes, we do have discovery. We would like to request an in-person preliminary examination for May 5th at 11 o'clock.
Okay, May 5th at 11 o'clock. Let me make sure I write that down. Okay, anything else?
Nothing further on behalf of the defense.
Ms. Blackton, your exam has been set for an in-person preliminary examination, May 5th at 11 o'clock a.m. at 36th District Court. Understand that?
Yes,
Okay, go have a good day.
you
All
too.
Okay, Attorney Dupree,
Good morning, Your Honor.
good morning. This is case 2258005, people of the state of Michigan versus Iron DeMarco Neely. Mr. Neely is charged with one count of breaking and entering a building with intent set for a probable cause conference. Appearances?
Alexander Kirk on behalf of the people, P86282.
Matthew Dupree, P80132, attorney for Mr. Neely.
And is Mr. Neely present?
He is not, Your Honor, and I have not been able to get a hold of him at the number provided to the MDIDC at the time of his arraignment. I'll also note that he capious the last time he was up, and the address that he provided was the same address as last time. I've sent letters to him. I have no explanation for why he's not here and no reason to believe that he's going to appear.
Anything from the people?
People remember tickets.
Okay, it'll be 1,000 in cash or surety.
Thank you, Your Honor.
You're welcome. Anything else?
No, Judge.
Okay, that's a good one.
You too.
Attorney Roberts, ready on your client's case?
Yes, thank you.
Okay, we're on the record, this is the people of the state of Michigan versus Gino Reed. Case 2356359. Mr. Reed is charged with count 1, weapons carrying concealed. Count 2, weapons owning firearms, second offense notice. Count 3, weapons, firearms possession by felon. The habitual offender, fourth offense notice set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor, Madam Clerk, Madam Court Reporter, Jonathan Roberts, P86428, on behalf of Mr. Reed, who is present via Zoom. Mr. Reed, could you please state your name for the court?
Javon Reed.
Okay, and Attorney Roberts, do you have discovery?
We have only received paper discovery so far, so we would be asking for another date. Mr. Reed has informed me that he is in the process of retaining counsel. So I am more than happy to, continue to represent him until that transfer happens. I do believe that you have a date on May 5th for 11:30 reserved for preliminary examinations. If we could get a PCC for that time, and then hopefully by then, Mr. Reed will have retained counsel, and then this can be set for next time.
Okay, Mr. Reed, when you say that, or your Attorney Roberts is saying that you're in the process of obtaining counsel, what's the timeline?
Excuse me, can you say that again?
When are you hiring your attorney?
Actually in the process now, I'm trying to get her on board now. Couple dollars short, so I need to continue to go to work so I can be able to pay her.
Okay, so I can't continue to delay this case without any type of timeline as to when you're going to hire counsel.
By the 5th, I should have her.
Okay, all right, so since it's just going to be a probable cause conference, Attorney Roberts, I'm going to schedule it for 8:30.
Yes, Your Honor.
Okay. So I will set it for May 5th, 8:30. And hopefully, Mr. Reed, you'll have counsel by that time. And tell your attorney to file an appearance. Your attorney knows exactly what that is as soon as that attorney is hired by you, okay?
Okay.
All right, so that'll be 8:30, May 5th, for a probable cause conference, the same thing that's happening today, Mr. Reed, on Zoom. Okay,
Okay.
anything else?
Nothing from defense, Your Honor. Thank you.
Okay, you all both have a good day. You're all set, Mr. Reed.
All right, thank you.
Thank you, Your Honor.
Attorney Howell, good morning.
Good morning, Judge. I'm here for D'Angelo Anderson. Has the competency report came in?
I don't think so. Let's check. Yeah,
We've been waiting like over a year now for this.
I didn't hear what you said. What'd you say, Attorney Howell?
We've been waiting over a year now for this.
Okay. The clerk is actually on the phone with the forensic center now.
Okay,
Just give us a moment.
all right, thank you.
Attorney Quinn, good morning. Attorney Quinn, you ready on fifth, sir?
I'm sorry, did you say Attorney Payne?
No, Attorney Quinn.
Okay, sorry.
Okay, fine. Case 2259230, the people of the state of Michigan versus Jermaine Fenster, charged with count 1, weapons, firearms possession by felon, count 2, weapons carrying concealed, count 3, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams, counts 4 and 5, weapons owning firearms with a habitual offender fourth offense notice, set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Fenster, who is appearing via Zoom and consents to appearing via Zoom.
Okay, Mr. Fenster, can you please state your name for the record?
Jermaine Fenster.
Okay, and Attorney Quinn, do you have discovery?
Yes, I do. I'd like to just set it for exam.
Okay, let's see, I will resend the message. I have dates available. I just sent dates. Attorney Quinn, I sent dates in the chat for you to look at. Actually, there's an exam already set, a date's already set for 4/28 at 10:30.
It's gonna make it hard for a nigga.
We're good to go on 4/28 at 10:30.
Okay, Mr. Femster, your exam has been set for April 28th, 10:30 a.m. at 36th District Court in person. Okay,
All right,
all right, you have a good day, sir.
Oscar.
Okay, Attorney Payne. Janelle Ponder.
Out of here. I cut this shit off.
Did you spare something?
Yeah.
Yes. Janelle Ponder. Thank you. This is case 2356345. Commissioner versus Janelle Ponder, who was charged with one count of robbery armed, set for a public cause conference today. Appearances.
Alexander Kruger on behalf of the people, P86282.
Morning, Your Honor. Sharon Payne, P38749, representing Miss Janelle Ponder. Your Honor, I will waive Miss Ponder's presence for today's hearing only.
Okay, I believe she's in custody. When she logs on, I will let her know of her exam date. Do you have discovery, Attorney Payne?
Yes, we're requesting an exam date of May 5th at 10 o'clock.
Okay. Anything else?
Yes, Your Honor, there is a couple of things. While I did get discovery, the digital is I'm having a hard time opening. If prosecutor can please just resend the digital so I can open that. And Your Honor, I'd like to address bond. My client's father is on Zoom this morning, Mr. Smith, and he's indicated that Ms. Ponder can reside with him throughout this case. Currently, the bond is $20,000, 10%. She is without funds to make that bond. I had a conversation with her in the Wayne County Jail last night, and we're requesting $10,000, 10% with a tether.
Anything from the people?
Given the assault nature of this crime, people would ask the bond answer.
Attorney Payne, I am, based off of what I have in the file here, I am not inclined to adjust bond. I will order a DSU report, however. And once that, I can contact if you'd like to address bond before the exam.
Understood, Your Honor. Thank you.
You are welcome. Anything else?
Nope, that's it, Your Honor. Appreciate it.
All right, you all have a good one.
I had just texted you a number.
Attorney Hamilton, good morning.
Good morning, Your Honor.
You have today.
I have Mr. Jacob Mackless. I don't know if he's able to zoom on.
He is not here.
Okay, he did text me that he was having issues with Zoom. I wonder if I can waive his appearance this morning. I'll just be requesting an exam date.
Okay, that's fine. I am sending in the chat the available date, and I will waive your client's presence. This is case 2356357, the people of the state of Michigan versus Jacob Mackless, who was charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Mackless. He's not here today, Your Honor. I think he had issues with Zoom. We request to waive his presence.
I will waive his presence. You have discovery, correct?
I do have discovery. I'm just in need of digital discovery. Otherwise, we'd like to set a preliminary exam date, Your Honor, for May 2nd at 1:30 if possible.
May 2nd at 1:30?
Yes.
Okay. And Mr. Kirker, do you have any insight on the digital discovery? Okay.
Does not look like we have any at this time, but I can email the officer in charge and find out if there any exist.
Okay, thank you.
Okay, so it's been set for May, what is it, May 2nd at 1:30?
Yeah, sounds good, Your Honor.
And is there any, well, Mr. Kirk, you're saying you don't know if it exists at all, correct?
Yeah, I haven't looked at the file.
Okay, all right, so you need to look at that. Okay, anything else?
Nothing further, Your Honor.
Okay, have a good one.
You too.
Attorney Howell,
Yes,
your client was last seen on February 15th at the present. So, client was interviewed on February 15th.
I'm sorry, Judge.
Your client was interviewed on February 15th.
Yes, he was interviewed. And we
Yes,
just
so-
waited for the actual report.
Correct. They gave no timeline.
No, it's with the doctor. She said she was police waiting.
Okay, well, the report is being drafted by the doctor, Attorney Howell.
Okay.
30 days.
Sure, Judge.
Okay, and after that, we're gonna do something different.
Absolutely. Thank you.
You're welcome. Let me give you the exact date. It'll be let's do the 17th of May. Does that work?
Yep, that works for me.
Okay, 9 o'clock.
Okay, thank you.
You're welcome.
Good morning, Judge.
Good morning, Attorney Davenport. Give me one moment, please.
No problem.
Where's the time? Attorney Davenport, good morning.
Good morning, Judge. I am actually scheduled to have an examination at 10:30 a.m. before this court, as well as an examination following right after 10:30 at 11 a.m. I actually still do not have my discovery that was signed and ordered to be produced. I believe I can give you the exact date, Judge, but I actually put it on the record, and then I came in person and had a wet signature, and I provided a copy to the prosecution on both cases, on 3 cases, but 2 of them are still going today.
I see one case with your name on it. You have one at 11 too?
Yeah, I'm standing in for Attorney Curtis Davenport.
You have the defendant's name on?
Yes, the one for 11 would be Damian Johnson.
Okay, all right. Okay, well, we're in the middle. We got 3 exams that we're in the middle of right now.
Okay, I actually just want to know before I drive down. I'm an hour away. I don't mind coming, Judge, but I was going to be requesting a dismissal on both of those cases. The discovery orders were already signed. The discovery is actually critical to this case. So I did place everything on the record. I did contact prosecution also as requested, and I still don't have anything.
Okay, I can't address it right in this moment. The prosecutor hears you. Actually, I don't know because she's in the hallway who's handling your cases.
Okay.
But if you want to hold on a second, hold on a couple minutes.
Okay. Thank you, Judge. I appreciate it.
Your Honor, has Mr. Ardell Harrison arrived yet?
No, nobody else in the jail. They logged off and didn't call back.
Okay, he may be in prison.
He is.
I'll log back in. I'm in another hearing. I'll come back. Thank you.
Okay. It's not. She's 45. If they're not ready. Oh, Mr. Brown, good morning.
Good morning.
I just need to know, what are your work hours?
Like 7 to 7?
7 a.m. to 7 p.m.?
Yes, ma'am.
Okay, so I'm going to remove the house arrest. I did remove the house arrest requirement, but I'm going to put a curfew. So your curfew would be 10 to 6.
10 to 6.
10 p.m. to 6 a.m.
Oh.
Okay. You have a question?
10 p.m. to 6 a.m.
I'm sorry, yeah, in the house. You must be in the house.
Oh, okay, okay. I thought okay, okay.
I'll make that clear.
All right, yes, ma'am.
And your work hours are 7 to 7. Where are you working?
Masonry. It's not a company, but my boss, she gets jobs.
So basically like a judgment worker?
Yes.
Okay. But it's in, what type of work is it?
Masonry.
Mason. All right, thank you. I'm glad you updated it now and send it over to the television.
All right.
So the person logged on is Life 3. What's the name?
Chesterfield.
And Mr. Chesterfield, you need to take off your hat. You're in court.
Okay.
Have you talked to your lawyer today?
I had called that lawyer. And he supposed to call me. I never got in contact with him.
Today, Mr. Chesterfield. That's all I want to know. Have you talked to him today? Okay, I'm gonna put you to the breakout room. We are in the middle of an exam. You're 45 minutes late for your court case. I will address you when we have the time to do so.
You're on.
Oh, yeah. Yeah, I just put on your curfew 10 p.m. to 7 a.m. You should be all set.
said 15 is 30 seconds. 30 seconds.
Ms. Christian.
Yes,
Morning.
good morning.
Your exam is set for April 24th at 1:30 at 36th District Court in person.
Can you say that one more time?
Sure. April 24th at 1:30 p.m.
And what, you said what was that again?
Your preliminary examination.
Okay,
So that's where testimony may be heard, witnesses may come, depending on, I can't say what will happen, but that's the day you need to be in person at 36th District Court.
okay,
All right?
okay, thank you.
You're welcome. Have a good day.
You too.
Sure. Yeah, show up, yeah, those are 9 a.m.
Okay, we're ready on Smith? Yes, Your Honor. Thank you for your patience. Okay, this is case 2355757, the people of the state of Michigan versus Cherry Ray Smith. Ms. Smith is charged with one count of assault with a dangerous weapon, felony assault with an habitual offender third, and notice set for an exam today. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495. Good morning, Your Honor. Monica Walrad with NDS P85665 on behalf of Ms. Charity Smith, who is present in the courtroom. Ms. Smith, you can state your name for the record. Good morning, Your Honor. Charity Smith.
Good morning, everybody. I know this was adjourned due to this attorney Walrad requesting a video that was missing that she only knew existed from the discovery pack. Is that correct?
Yes, Your Honor. That video has been produced.
It's been provided?
Yes.
Okay. Is everyone ready to proceed?
Yes, Your Honor.
I'm sorry, ma'am? Is everyone ready to proceed?
Yes, Your Honor.
Okay. Any preliminary matters?
None of this, Your Honor, state that the OIC is in the courtroom. Councilman Church, I would state your name for us, please. Detective Jenkins is in the courtroom. We do not anticipate needing her testimony, therefore, otherwise, no one else in the courtroom on our part. No objection to her. Presence, Your Honor. It's just what I see.
Okay, can you make sure you speak up? Otherwise, just Walrad.
No objection to her presence in the courtroom from defense as she is the OIC.
Okay, any other preliminary matters?
None from the people, Your Honor. None
Okay.
from the defense.
You call your first witness.
Thank you, Your Honor.
See you now.
Your Honor, the people called Deja Benson. Sorry, fine. Okay. Thank you.
And I swear you to more. Raise your right hand. You swear to tell the truth, no truth, and nothing.
Yes.
Okay, so the door opens right here in the front.
Okay.
Have a seat and put that microphone in your lap. Make sure you speak up.
Okay.
And I'll give you some tissue for your nose.
Thank you.
Thank you, Your Honor. I'm going to ask you a few questions as the judge has instructed you. That is perfect having the mic on your lap. If I ask you something that you do not understand, please stop me and show me your rephrase.
Okay.
Could you restate your name for the record, please?
Deja. I'm sorry.
Okay.
Deja.
Deja Benson? Can I call you Deja?
Yeah, you can.
Thank you. Deja, I want to take you back to the day of July 1st, 2022. Do you recall that, Deja?
Yes, I do.
Were you at the location of 5748 Emerald Springs Circle in the city of Detroit, County of Wayne?
Yes, I was.
Your Honor, I just want to make a note that the information felony report has location as 5746. It did happen on the exterior of residents' homes. So I have stated the correct address is 5748, but it was in that vicinity, so it wasn't exactly at a location. So I just want to point that out, that is why we stated a different address.
Any objection to the best on the chain for any?
No objection to that, Your Honor. It doesn't seem significant. Yeah.
Okay.
Thank you. What's at this location, Deja?
Repeat that one more time for me.
What's at this location?
My home.
Okay. And who resides with you at your home?
Me and my two boys.
Okay. On that particular day, who was with you?
My two boys.
Okay. So did something happen at this location on that day to bring you to court today, ma'am?
Yes, it did.
And what happened?
I was coming home from the gas station and I was approaching my back door when the defendant came running out of her house trying to attack me with a stick.
Okay. So I know you indicated the defendant, so more specifically, I assume you can identify this person?
Yes, I can.
Is that in the courtroom today?
Yes.
Okay, can you please tell the court where this person is and article of clothing they're wearing?
They're sitting right behind you. She has braids and a white coat.
Your Honor, the record reflect the identification of the defendant, Attorney Smith. Yes. So I know you give us a little bit of detail, but I'm sorry, could you tell who's the defendant to you?
She's my neighbor.
Okay, where relative, when you say neighbor, where directionally is she your neighbor?
Like directly next door.
Next door?
Yes.
Okay. So, can you tell us, what led up to this physical, this incident?
This probably started a couple years ago with our son, probably exchanging words with each other, and then so on, later on, it just started getting to where she started to want to physically fight me.
Okay. So this has been going on for a little while as far as like
Just-
verbal
yeah.
altercations?
Yes.
Between your two families?
Yes.
Okay, so on this particular day, how did you first come into contact with the defendant?
I was coming home and I was approaching my back door.
Okay. And is that where you often, is that where you normally, when you say you're approaching your back door? Could you
Yes.
describe that?
Sometimes I come in from the back to avoid, my neighbor approaching me in the front sometimes. And sometimes I go towards the back and then that's when she came out at me full force before I could even get to my door.
Were you on foot or were you in your vehicle?
I was on foot, I was walking. Yeah.
Alright, and So when you first came into, you said that, you came into contact with her, how did you first see her?
I was walking up towards approached my door, and soon as I was looking up, she came running out full force at me, and then I just turned around, I just ran.
Okay, so when you say she came out, where did she come out of?
Her back door.
Okay. Did she say anything to you?
She said, bitch, I'm gonna put you on a t-shirt.
Okay. Was she by herself?
No, she had her son, recording her as she approached me.
Okay. When you say recording with what type of device?
He had a cell phone in his hand.
Okay. So after, I assume words were exchanged, I know you just said that she had, made a comment about putting you on a t-shirt, but, did you, have any response to her prior to, I know you said you took off, but prior to that?
No, I was just in shock. I just got in my car and ran straight down to the office.
Okay.
Yeah.
So when you say you got into your car, did you observe the defendant, what was the defendant doing when you got into your car?
At this point, I'm pretty sure she went back into the house, and I guess she came out the front door yelling at me as I was getting into my car. And I just left, went down to the front, the rental office of our complex.
Okay. So you mentioned at the beginning of this something about a stick. When did you see a stick?
As soon as I was approaching my back door, when I was coming from the store, when she came out full force at me.
Okay. So where was the stick when you saw her, when you were approaching your back door?
It was in her hand.
Okay. Can you describe this stick to us?
The stick was about this long, and she was holding it like this, and she was swinging it.
She was swinging it
at me, and I was backing up, and then I just took off and ran.
Okay, so I'm just trying to
Verify the length of the stick.
Yeah.
I don't know, type of thing, this might go like this.
3 feet and
Yeah.
a yard, like a yardstick?
Yeah, something like that, a rabbit stick.
So I know you're describing now the size of the stick. I'm just trying to get a visual. Is this like a stick that you, like a branch? Is this a stick like a log? Or is this like a pole? Is this a physical stick like from outdoors?
It looked like it was a physical stick from outdoors. Sometimes it can be other little things that look like that, but I'm pretty sure it was a regular branch log stick.
Okay.
From like outside.
Okay, and you indicated that she was swinging this?
Yes, she was.
Okay. When she was swinging this, what were you thinking?
That she was physically trying to harm me. She was trying to really hurt me now. So I was scared. I feared for my life, and first thing I knew was to run.
Okay.
Leave.
To leave? Okay. So your response was to leave, and you indicated that you left via your vehicle, so you ran to your vehicle?
Yeah, I ran straight to my vehicle.
Okay, where did you go with your vehicle?
I went straight down to the rent office, which is inside of our complex.
Okay. So once you got to the rent office with your vehicle, did you stay outside? Did you go inside? What did you do?
I parked and went straight in, buzzed the buzzer, and I asked to speak to someone, and they let me in.
At this time, as you were entering this office, were you, I don't know exactly where this office is relative to your home. Were you able to observe the defendant still at this time, or were you now out of her sight?
I was out of her sight, but I didn't observe her until like 3 to 5 minutes of me being inside her, and then that's when she came.
Okay. So once you went inside, why did you, and I apologize, why did you go inside the rent office?
Because I wanted the office to see what was going on, and I wanted them to capture her in the act.
Okay.
So that's why I went down there, so they could, see what was going on, and it just was.
I did it with no video. I joined it, no video.
So
Judge, you were just saying, while you were in the office, did you come into contact with the defendant again?
Yes.
Okay, and what happened, when did you observe the defendant while you were at the, rental?
As I was, making my, complaint to the office, and I was telling them what was going on right then and there, that's when she came down here and her hand with the stick in her hand.
She still had the stick?
Yes.
Did she exit the vehicle with the stick?
Yes, she did.
Okay. So what was she doing with the stick outside the rental office?
I guess she was trying to get in there to me, to I guess finish what she started.
Okay. Did you make any observations of the people that were with you?
Yes, I was telling them, one of the ladies at the office, what she had in her hand, and they just so happened, as I was explaining it to them, they just so happened to see her pull up. And I said, there she go right there, and they wouldn't let her in because she had that stick in her hand, so they locked the doors.
Okay. So did you actually observe them lock the doors?
Yes, I did.
Okay. And I just want to clarify, you said they wouldn't let her in. Did you make any observations of her attempting to come in?
Yeah, she was pulling at the door, and one of the ladies that I was talking to about the incident, she told another person from the office, lock the doors and get on the phone and call the police. Don't let her in.
Were the police actually called? Did
Yes.
you observe someone calling the police?
Yes, they
Okay.
did. They did come.
Where was the defendant while they were calling the police?
Still outside, still trying to get in.
Okay. Did she retain this stick in her hand at all times?
Yes, she did.
Okay. Did the police arrive?
Yes, they did.
Okay. Did you make a statement to the police?
Yes, I did.
Okay. Did you provide the police a description of who had done this to you?
Yes, I did.
Okay. Do you still, just a couple more, do you still reside at this location?
Yes, I do.
Does the defendant still live next door to you?
Yes, she does.
No further questions.
So, you said it's about 2 years of conflict between the two of you?
Yes.
Okay. Did you have an argument earlier that day with her?
No, I did not.
No, okay. So the argument this day started when you came back from the gas station?
Yeah, it did.
In the time that you had the conflict before, both parties have made police reports, correct?
Yes, I believe so.
And both parties at the time of this call had made police reports where they were working with a detective or detectives.
Judge Drown, I apologize, I just to get some clarification as far as both parties. Are we asking about the defendant and the? I would just object to, just so that Ms. Benson only answers to things that she actually observed happen.
Yes.
That's fair, that's fair.
Ms. Benson, if you know, you can answer the question.
Okay.
Do you know?
Oh, I do not.
Okay, no apologies then. You said on direct examination that you would go to the back door in order to avoid being approached to the front door by a neighbor. Did you mean Ms. Smith or did you mean a different neighbor?
I meant her.
And you said that her son was with her filming the
Yes.
interaction? Okay. Were you aware that she showed the video that her son took to the police when they arrived at the rental office or not?
I don't know.
Okay.
I don't know.
Do you recall saying to her during the words exchanged this day the first, that was why you had smashed the windows of her car?
I said that just from how she embarrassed me, trying to approach me, so I said it to make her angry, but that never did happen.
You said it in order to.
I just said it to just make her mad because how she came at me with this thing. So, besides me trying to fight her, just said something to make her mad as I was getting in the car, and that's when I went down to the office.
Okay.
A little bit for that. Yeah.
Okay, I'm sorry.
Thank you.
So that was According to your direct exam, that would have been after she was already approaching you with the
Yeah.
stick. You said something
I
to make
said
her.
it just out of anger.
Okay.
It wasn't true, but it was just out of anger.
Do you think that she could have believed that it was true, given that the windows of her car had been smashed?
I don't know if she believed it or not, but I had nothing to do with it.
Okay.
At all.
Okay. I know I'm going to ask you something that might be a little bit hard to remember or to express verbally. How far away were you from each other at the point that she came out?
It was real close.
In
I can't remember the feet, but it was close enough. She was approaching, she was coming at me. So I can't recall the numbers of steps or foots. All I know is she ran towards me and I ran.
But you were able to get in your car?
I was able to get to my car.
Okay.
Because I took off pretty fast.
Okay. So far enough that you were able to get into your car and drive away without having physical contact?
Yeah.
At that point, you went to the rental office?
Yes, I did.
Okay. While you were at the rental office, they locked the doors?
Yes, they did.
Okay, and so when the approach the doors second time, there was no chance of physical contact?
No, because they locked the doors. They called the cops.
Were you aware that both parties, yourself and Ms. Smith, called the police, or were you not?
I wasn't aware of that.
Okay. And two officers responded to the call at the rental office?
Yes, they did.
Okay. They took a statement from you at that time, a verbal statement?
Yes, they did.
Okay. And at that time, they didn't express to you that they were going to file a report on this incident or look into this?
They did express that to me.
They
That
did?
they was gonna, proceed through everything. They just told me it was gonna take a little bit.
And those officers left without making a report?
Yeah, they actually, the same officers and the jurors actually followed me down to my home to make sure I got down there safe. So he followed behind me when we left the office.
So you said it was 3 to 5 minutes later that the Smiths came down to the office?
Yeah, because I was down there first explaining my side to them.
Okay. Have the two of you both spoken to the rental office before about this conflict?
I'm not sure on her behalf, I can only speak for me. Yes, I have numerous times.
And did you see her personally approaching from her car with a stick to the office, or was that relayed to you by the?
Me and the lady in the office, rental office, who actually works there, we both seen it through the glass as she was pulling up and she was approaching. I told them, there she goes. They said she's not getting in here with the stick, lock the doors and call the police, and that's exactly what happened.
Are you aware whether your apartment building has a security camera?
I'm aware that it does, the green light, but I don't know exactly how the actual footage and stuff like that, like in the inside, stuff like that. I'm not sure about that. I just know it's a green light.
Okay. And are, so you, again, to go back, you had informed Ms. Smith whether truthfully or not that you had busted in the car.
That's not true, but I just said it because.
But you had informed her of that
Yeah,
in a way.
I just made it right, it's just for example, as if like somebody's arguing with you, you randomly make somebody mad, I say, oh, that's why I slept with your man. It was something like that, not saying I actually slept with somebody's man, it was just said to just like, I can't physically touch you, so I'm gonna just say something to make you mad.
Okay.
So that's why I said it, that's why I said
Okay,
that.
so it was intended to and could have made her feel threatened.
Yeah, just to make her mad, how she came at me with the stick, so I couldn't touch her, I couldn't fight her, so I said something to make her skin.
Okay, and that's something that might, that someone might then report to a rental office recently.
Yeah, but it wasn't true, she has no proof that I did anything to her car.
Well, the car had it, correct?
But it wasn't me.
Objection, Your Honor, what's the relevance of this? Did this happen on this day or?
It did not, so why?
The relevance is, it goes to why both parties then went to the rental office, believing that they have something to report.
On that day, we know why she went to rental, she got chased there.
Thank
But
you.
I mean, it
Why my
appears,
client?
well,
I'll allow it. I think it
already been answered, we don't have to keep hearing things, questions.
Okay. No further questions at this time.
Redirect. No real questions, Joe. No, sir, it's good to you, step down.
Thank you.
Any other witnesses? No, Your Honor. That's all. Yes. Okay, Your Honor. So it's been mentioned, that's how you begin.
Thank you, Your Honor. The people move that defendant Charity Grace Smith be found over on count 1, assault with a dangerous weapon, felonious assault, and we reserve argument. Thank you. Your Honor, the defense would object to bind over the witness. There was only one witness, and this witness admitted that she has a long-standing personally motivated conflict with Ms. Smith, which colors her perception of her actions. She admitted that she was saying statements deliberately to make Ms. Smith feel threatened, angry, or in fear during the conflict between the two of them. She said this after she said that she felt that she was in fear for her own physical safety, which in my opinion is somewhat unreliable testimony. If she was in fear for her immediate physical safety, making the other party angry does not seem like an intuitive response. The court is obligated to make a finding as to the credibility of the witness. The witness is not credible regarding this incident or this conflict. And so I ask that the court dismiss rather than find.
Anything from people?
Yes, Your Honor, thank you.
Your Honor, people respectfully disagree with the defense. This is a probable cause hearing, and as such, at a probable cause standard, we don't need to bring all the witnesses. However, the testimony did indicate that there were other witnesses that were at the actual rental office that obviously we, you know, just by hearing the testimony, the observations that they made, the complaining witness observed them not only call the police, but keep the doors locked in order to keep the defendant out. These actions alone could allow one to believe that they also observed, just like the complaining witness stated that they did, observed actions from the defendant to put them at fear enough to have to call the police and keep doors locked. That being said, I do not believe that our complaining witness has any credibility issues. The fact that she did not respond in the way any of us would have, and that's not really to say that any of us would have. She indicated that she made statements, a statement in regards to doing something to the defendant's windows, presumably not on that date, but in response, as she said, after she saw her with a stick. But at the same time, whether it's before or after, I'd be inclined to say that this gives the defendant reason to attack the complaining witness. If one thought that her windows were broken, she might take a stick and want to handle things. However, that is felonious assault. We don't handle things like that. I understand that police have been called back and forth if those incidents come to be, and if this complaining witness has done something, those incidents would come before this court likely as well, if there is evidence to prove of such. But on this particular day, The testimony indicates that our complaining witness did everything in her power, including going to the back door to avoid a neighbor, the defendant, who she has continually had back and forth with words. And this neighbor, the defendant, came out of her house immediately, had words with her again, and not only had words with her, which had that been left at that point, we wouldn't be here today, but she actually had a stick. And that stick was used as a weapon to chase after the complaining witness. And she did put the complaining witness in fear. Not only did she indicate that she was fearful that she was going to be physically harmed, but her actions alone. She ran from her, got in the car, and then ran for assistance to the rental office where they locked the doors and called the police. So unfortunately, we hate to see this. We're neighbors. It starts with children and adults get involved, and then it escalates after a long period of time to this. It's very unfortunate, but at this point in time, we believe probable cause has been met, and that the witness does not have credibility issues based on her testimony. As I stated, probable cause has been met, and we appreciate that the defendant be bound over on count 1. Thank you.
Okay, people have to prove at the probable cause standard first, that the defendant either attempted to commit a battery on a witness, or did an act that would cause a reasonable person to fear or apprehend immediate battery. We believe people have met it for proof. The actions as explained by the complaining witness, I believe the actions described that the defendant committed will cause a reasonable person to fear or apprehend immediate battery. That would be the stick that was described almost 3 feet long from outside, and was used in a manner in which the defendant said, "Bitch, I'm going to put you on a t-shirt." 2, second, that the defendant intended to either to injure the complaining witness or to make the complaining witness reasonably fear immediate battery. I do believe for count 2, the actions of the defendant would have the reasonable person fear immediate battery, that being with the same stick. Third, at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought she had the ability. I do believe the defendant had the ability to commit a battery, appeared to, and thought she had the ability. And lastly, fourth, the defendant committed the assault with a dangerous weapon. So for count 3, I believe the people have met for the probable cause standard. And the fourth element, that the defendant committed the assault with a dangerous weapon, and that weapon being the stick from outdoors. It does not have to be an object that is specifically designed to be dangerous, but something that could be used as a dangerous weapon. And I do believe that stick of that nature as described was a dangerous weapon at that time. I know there are some issues with prior arguments and verbal altercations, and maybe be some damage to physical property. However, that does not negate the action as described by the complaining witness. It doesn't justify it based off of what I've heard. So I am going to find out the defendant on that 1 count for felonious assault. And the arraignment information will be May 2nd, 2 weeks from today, 9:00 a.m. at Frank Murphy Hall of Justice. Anything else?
Your Honor, may I just ask what the current bond restrictions are? Obviously, these 2 people live next door to each other. I believe these women both have children. I'm not trying to make matters worse for the defendant, but I would like no contact. Yeah, I'd like to reiterate the no contact. And I will reiterate it to also the complaining witness.
Yes, it goes both ways. No social media, no through other people.
And I was gonna mention that because I believe there's children involved, and that's how this all started. So, and I know we can't always control our children, but maybe to reiterate to the children so that they don't get the parents in any deeper trouble.
Yes, the people that complaining with know as well.
I don't believe that either party wants to have contact with each other. I would just know that the children are 11, so that advice given to them might not be the strongest. But
okay, we're off the record on this one. Attorney Jefferson, we have the division one is called in, but there's no one in the chair. So no one's come to the camera.
Okay, I'll just wait, Judge. Thank you.
Yes, who do you need from Division One? I'm sorry. Who are you waiting for from?
Can you please come or talk to your attorney so we can call your case? Your case was scheduled for 8:30. Mr. Chesterfield, unmute your device, please. And good morning to the deputy at Wayne County Jail.
Good morning, ma'am.
How are you today?
Are you ready for Ms. Ponder or Ms. Bennett?
Let's see. You would happen to have Harrison though.
Harrison?
Harrison, Ardell Harrison.
I didn't know he was on the docket. Let me see if he's in custody. Can you look it up for him? Harrison.
Do you have Henry?
We don't. Ardell Harrison is not in custody.
Okay. So you have, say who you have again, you have Ponder.
Yeah, Janelle Ponder and Delexis Bennett for a tether violation.
Okay, so for Ponder, she just has an exam date for May 5th at 2 o'clock.
May 5th, 2 o'clock. Okay, and we're still waiting on the attorney for Ms. Bennett.
Yes, we have to get an attorney for the tether violation.
Okay, no problem.
Attorney Jefferson, I'm going to do a waiver. Do you want to, after I do this waiver, have your case called and waive your client's presence?
Yes, Judge, please.
Okay. Let's handle Davion Gabo. This case 2356159, the people of the state of Michigan versus Davion Jamel Gabo, who was charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and or obstructing, count 3, weapons, felony firearms, set for a preliminary examination.
Good morning, Your Honor. Daniela Parrish on behalf of the people, PA 5495.
Good morning, Your Honor. Jonathan Simon, P 35596 on behalf of Mr. Godwell.
Mr. Gabo, please state your full name for the record, please.
Davion Godwell, Davion Jamil Godwell.
Thank you. Good morning.
Your Honor, today is the date and time set for preliminary examination. Although the people are ready to proceed, I believe they will not object to Mr. Godwell waiving preliminary examination.
That is correct, Your Honor. No objections. Okay. Mr. Godwell, I'm going to ask you a series of questions. If you don't understand my questions or if you can't hear me, let me know, okay? Okay. Is it your wish to waive your exam today? To make sure you speak up.
Yes, ma'am.
You understand you have a right to a preliminary examination?
Yes, ma'am.
And that if you were to demand that exam today, the people would have to show at the probable cause standard, which is a much lower standard, but still a standard in criminal law, that those charges I read off in the information were committed in the city of Detroit and that you probably committed those crimes. Do you understand that? That by waiving your exam today, that means that people do not have to show any evidence or prove anything today. Knowing that information, you still wish to waive your exam? I also want to let you know, you understand you're not waiving your right to trial. You understand that? Did anyone force you or threaten you to waive your exam?
No, ma'am.
Okay. Did anyone promise you anything?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information. It will be 2 weeks from today, so that will be the 2nd of May at 9:00 a.m. Anything else? Okay, bond is continued.
Thank you, Judge.
You're welcome. You're welcome. Good day. Ready on Avery?
Yes, Your Honor.
Okay.
Your Honor, you say you're gonna call my case?
Yeah, I'm about to call it now. Case 2356060, the people of the state of Michigan versus Ardell Harrison. Mr. Harrison is charged with one count of police officer assaulting, resisting, and obstructing, visual offender third offense notice, set for a probable cause on this day. Harrison.
Alexander Kirker on behalf of the people, P866282.
Good morning, Your Honor. Thomasine Jefferson, on behalf of Ardell Harrison.
And, or you believe him to be in custody, he is not. Have you had any contact with Mr. Harrison?
Your Honor, he is in custody. I will waive his presence for today. I think he's at MDOC and I'll track him down.
Okay. All right, you have discovery?
No.
I can send over discovery if we have it.
Okay. Okay, Attorney Jefferson, did you look at the dates that were provided?
Did I see a May 1st date, Judge?
That date is gone. Let's see. I'll send you the updated date here.
We have a dismissal on Mr. Matthews. If you all are getting ready to hold an exam, I have 3 clients across the street that have
That's
been
all
waiting.
right.
Can I go across the street?
Judge, May 10th at 11:30.
I don't have May 10th, May 3rd, 4th, and 5th is the earliest, but if you want to go that far out, send it to MDLC, I'm okay with that.
Yes.
Okay, May 10th,
Yes, Judge.
11:30, okay. Good
Thank
stuff.
you. Thank you so much.
You're welcome. You have a good rest of your day.
You too.
Attorney Winters, good morning.
Good morning, Your Honor.
Who do you have today?
Miller, James Miller.
I don't see a James Miller. Oh, 11:30. Yes, okay. What's going on?
Well, Ms. Parrish called yesterday indicating there was a somewhat of a mix-up in terms of scheduling. So I told her on the phone yesterday, I have no problem with the court adjourning. I think she'd already spoken with somebody on the court staff. But we have no problem with the case being adjourned, Your Honor.
Okay, let's see. Do you want something next week or the week after?
May 4th, if that's available, or?
May 4th is available. Do 9, 9:30, 10, 10:30, 11, 11:30.
9:30 would be great.
Okay, May 4th at 9:30.
Listen.
Thank you, Attorney Winters.
Thank you very much, Your Honor. Good
Have a
seeing
good
you.
one. You too.
Your Honor, do you have Henry? Your Honor, do you have a Henry?
Sir, what type of case is it for Henry?
It is a moving. We were supposed to go to court for.
You're in the wrong court. You're in the wrong courtroom. Let me give you the correct Zoom number. Are you ready?
Yes.
360.
360.
436.
436.
0000.
Okay.
Okay, thank you. You can log off.
Mr. Matthews. Calling case 1166363, People of the State of Michigan versus Boris Matthews, charged with one count of controlled substance possession, cocaine, heroin, or another narcotic less than 20 grams set for an example appearances.
People, P868282.
Good morning, Your Honor. May it please this honorable court, Attorney Phyllis Gayton Robinson, P71733, on behalf of Mr. Matthews, who is present to my left, Mr. Matthews.
Matthews. Exam is set for 9:30, time is now 10:05. Are the people ready to proceed?
The people are not, Your Honor.
Okay. Your Honor, based on that information, we are asking for a dismissal of this matter.
Is it because of any witness?
Your Honor.
It's a 2011 case.
And one of the officers is here, Your Honor, Officer PM, but he has no recollection.
Okay. Thank you. I will dismiss without prejudice.
Thank you so much. I appreciate it. Thank you, Your Honor. I appreciate it.
You're welcome. Have a good one. Okay, we're on the record. It's People of the State of Michigan versus Philip Avery, 2259174. Avery is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony firearms, second offense notice. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony firearm, second offense notice with an habitual offender. Fourth offense notice set for a preliminary examination today. Appearances.
Good morning, Your Honor. This is Dan Duquette on behalf of the people practicing under Michigan Court Rule 8.120 under the supervision of Alex Parker, key number 86282 in good standing.
Good morning, Your Honor. Attorney Sahar Barrage, number 85175, appearing on behalf of Mr. Avery, who appears to the right. Mr. Avery, can you please state your name for the record?
Good morning to everybody. And I will allow you to practice under Michigan Court Rule 8.120.
Thank you, Your Honor.
Okay, is everyone ready to proceed?
Yes, as a preliminary matter, the people would move to admit a certified register of actions. It's a copy of the defendant's previous felony charge of malicious destruction of personal property pursuant to MCL 766.11B 1B.
It has defense counsel had an opportunity to review the copy.
Not yet.
Yes, Your Honor. We have the opportunity of reviewing the register of actions, and we did not stipulate to the certified records of the register of actions. It's not a certified record.
You said you do not stipulate?
No, to the certified record of the register of actions as opposed to the certified record of conviction.
Okay, can I see the document?
Certainly.
Okay, it has a seal on it, and for exam purposes, so I will allow.
Blessings. You.
Okay, any other preliminary matters?
No further requests.
Okay. Nothing on behalf. Okay, if there's anyone on YouTube or anyone on Zoom who may be a witness on this case, now is your time to log off. Before you call your first witness, Attorney Elder, were you able to speak to your client finally?
No, Judge, I have not been able to connect with him. I apologize. I don't know if it's him or me. You can hear me, correct?
Okay, I'm just gonna adjourn it until tomorrow.
Okay, thanks, Judge.
Okay, let's do 8:30. We start exams at 8:30 tomorrow, so
Yeah, got it. Okay, Judge, thank you.
you're welcome. Okay, back on the record, I am for you, call your first witness.
Thank you, Your Honor. The people call Officer Brandon Newman to the stand.
Officer Newman. Over.
So. Raise your hand. Swear to tell the truth, no truth, nothing. You have to see the doors in the front here. Make sure you see them. Whenever you're ready.
Good morning, Officer Newman. Please restate your name for the record.
Officer Newman.
And Officer Newman, where are you currently employed?
With the city of Detroit.
And in what capacity are you employed with the city of Detroit?
As a police officer.
And were you performing your duties as a Detroit police officer on August 16th, 2022?
Yes.
And did your duties as a Detroit police officer take you to the address 15861 Marlowe Street?
Yes.
And is that in the city of Detroit, county of Wayne?
Yes.
Excellent. And did anything occur at or near that address that makes you?
Yes.
All right, so what happened at that address?
So there was an arrest made at that address.
Okay. And at that time, were you working alone?
Yes.
Were you in uniform?
Yes, sir.
And were you in a patrol vehicle?
Yes, sir.
Right. And you said you were not working alone, you were working with a partner, two partners?
Two partners, sir.
Excellent. And were you in the vehicle at that time?
Yes, sir.
And where were you seated in that patrol vehicle?
In front, passengers.
You were in the front passenger seat? And from that front passenger seat, what did you see there?
I observed the male, observed or looked in the area of a scout vehicle.
And you indicate a male. Do you recognize that male in the courtroom here today?
Yes, sir.
Could you please point to them and identify them by article of clothing?
It's going to be the gentleman right here with the green top on.
Thank you, Officer Newman. May the record reflect, Officer Newman has identified defendant Avery.
So reflected, also the people that might not be able to.
Okay, so you encountered the defendant in this case on that day at that address, and you say that he saw your patrol car, correct?
Correct.
After seeing your patrol car, what did you do?
Immediately started to walk away.
Okay, so he began walking away from your patrol car. At that point, how did you respond?
Once I see him
begin to walk away.
My partners and I actually stepped.
Okay, and why did you do that?
Because I observed Mr. reach for his waistband.
Okay, and what is the significance of reaching for his waistband? What is the significance of reaching for his waistband?
I can read through your
Can you give me a second, please? I can't hear well. You said what was the significance?
Correct, yeah, I was asking, the significance of seeing somebody reach for the waistband.
Just with my experience as a police officer, that's consistent with someone either concealing or discarding something.
Okay, very good. So at the time this individual reached for their waistband, were they located in the street?
No, I don't believe he was on the street.
Okay, where was he?
I can recall it's towards the bottom of the driveway, towards the sidewalk, the address.
Okay, of that address. So after reaching for his waistband towards the sidewalk at the bottom of the driveway of that address, what did this individual do?
He walked on the other side of the vehicle.
And the other side, meaning the other
Opposite side of where I was.
So you could not see this individual after they walked behind this vehicle?
Correct.
Okay. And once they walked behind that vehicle, what did they do? As far as you could see, what did they do?
Come up from around the front of it.
Okay, and at that point, where did they go from there?
Can't recall, I think right in the front.
Your Honor, I objection stipulation.
I couldn't even hear what you were saying. Can you repeat the question?
Yeah. So after this individual went behind this vehicle, behind being relative to your position, where did they go from behind that vehicle?
And that was your objection?
Yes, he said he doesn't recall.
Is that what you said?
Yes.
Okay. And if I provided you a copy of your report of that incident, would that refresh your recollection?
Yes, sir.
Okay. May I approach your honor?
Yes.
After reading your report, did that refresh your recollection as to where you saw the individual go?
Yes.
Okay, where did that individual go?
He stopped near the vehicle.
Okay, gotcha. So at this point, this individual has walked behind this vehicle. What do you do?
Immediately approach.
Okay, and you approach why?
Because I believed he discarded something.
Okay, and after approaching, what did you do?
I stood by with him. And then my partners, and my partners, okay. So my partners canvassed the area where we last see him on the opposite side of the door.
Okay, and during that process, did you see any?
Yes.
Okay, what did you see?
While I was standing with them, the same vehicle as we were talking about, I observed a handgun underneath.
You observed a handgun underneath that vehicle. And at that point, what did you do after observing?
I informed my partners.
Okay. And after informing your partners, did you then recover that?
Yes, sir.
Okay. And did you personally recover?
Yes, sir.
And did you make that weapon safe?
Yes, sir.
And what does that entail?
Excuse me.
What does that entail, making a weapon safe? What is involved in that process?
Removing a source of feed, which is the magazine, and making sure there's not a live round in the chamber.
Okay. And were there live rounds in that chamber?
I don't.
Would reviewing your report refresh your recollection?
Yes.
Let your report. I'm gonna go ahead and double check that. Were there live rounds in that chamber?
Yes.
Your Honor. Objection, Your Honor. Nowhere in his police report does it say that he removed any live bullets. All it says that he observed a handgun laying underneath the vehicle. Which, well, you only showed me that you showed this report.
My apologies, I tried to set it so you can see, or would you like to see the second page of that?
Sure. Is it the same? Report is the second page.
It's the second page of the same.
Okay.
And if you'd like, I can still provide. Now, in between the time that you saw Mr. Avery head to the other side of that vehicle and you approaching that vehicle, did anyone else come near that side of the vehicle where that pistol was recovered?
No.
And did the defendant indicate that they had a CPR?
He said he did not.
And did any further investigation of any type reveal that the defendant had a CPR?
Early, he did not.
No further questions for this witness, Your Honor.
Right, Baraj, before you begin talking, I just want to say something to the council. So Deputy in Division 1, there's an attorney here for Ms. Alexis Bennett.
Thank you. We'll get her right now in front of the screen.
Okay, I'm going to put you on to a breakout room so that Attorney Cohen can discuss some issues privately while we finish up this exam.
Good morning, Officer Newman. If at any moment in time you do not answer my question, please let me know and I'll be more than okay? You were asked questions about on direct about whether or not you were on patrol on August 16, 2022. Do you recall?
Yes.
It was your testimony that you were in a squad car that day, correct?
In a SWAT car?
Yes.
Correct.
Routine patrol. You're on routine patrol. But would you be surprised to find out that you were actually driving the squad car and not actually a front passenger in the squad car?
No, I wouldn't be surprised. I said I believe. So it's likely.
On direct, you testified being in the front passenger seat.
Yes, I believe being in the front passenger seat, possibly where I was in the driver's seat.
So do you remember being in the front passenger seat or in the driver's seat that morning?
I couldn't recall. That's why I said I believe.
When watching your body cam, refresh your recollection where you were seated in that squad car
Yes,
that morning?
ma'am.
Your Honor, if marking this as offense exhibit, letters or numbers? Letters, proposed exhibit A for purposes of identification and permission of.
No objection.
Yeah. It's a very short clip, it's at 3 seconds. For the record, I'm playing Brandon Newman's body cam. Oh, no, I don't need to see it if you're refreshing. Yeah. So, it's 3 seconds. Did you remember you refreshed?
Yes, ma'am.
Okay. Mr. Newman, you just watched a body cam video footage of yours, from your body cam of that day of the incident, correct?
Correct.
And you were seated in the, from what you saw in your body cam, you were seated in the driver's seat, correct?
Correct.
So you were not in the front passenger seat, right?
Right.
And as you're driving northbound on Marlowe Street, correct?
Correct.
That's a residential area.
Correct.
There's other homes in the area, correct?
Correct.
And this was happening during the day.
Correct.
So while you're driving, you're making sure, because it's during the daytime, to pay attention to see if there's kids outside, correct?
Correct.
You're being careful, paying attention to the road,
You can say that.
going the speed limit.
Correct.
And as you're driving down the street, that's when you first see the street. Correct?
As I'm driving down the street.
As you're driving down Marlowe Street, it's your testimony and direct examination that as you're driving down the street, that's when you see Mr. Avery.
Correct.
While you were still seated in the squad car, correct?
Correct.
All right, let's talk about what Mr. Avery does and doesn't do after seeing the squad car. According to you, Mr. Avery is standing in the street, right?
Near the street.
But according to you, he was working on a vehicle, correct?
Correct.
Is that a yes? He was not just standing in the middle of the street, he was working on a vehicle, correct?
Correct.
And then if that vehicle is a red car, correct?
I don't recall the color.
Okay, we'll get back to that in a second. So it was your testimony and direct examination that Mr. Avery then looks at the direction of your car, correct?
Correct.
And then when Mr. Avery sees you, he turns around, right?
Correct.
And then he walks away.
Correct.
But you observe all of this happen while you're seated inside, correct?
Correct.
Now, Mr. Avery was working on a car that was also parked in the street. Now, Mr. Avery didn't run away from the squad car, did he?
No.
All Mr. Avery did was look over his shoulder, see you guys, and walk away, correct?
Good.
Well, it was your testimony that you were driving down the street, correct?
Correct.
And he was also in the street, correct? Yes?
Correct.
So it's most likely that he was just trying to get out the way of the squad car, correct?
Possible.
Because he didn't run into the backyard of the house, did he?
No, I didn't see.
He didn't run into the house, did he?
Never said
He didn't resist arrest, did he?
No.
Now I want to focus on what happened after Mr. Avery was detained. You were one of the officers that detained Mr. Avery, correct?
Correct.
And once Mr. Avery was detained, he was searched, right?
Not correct. He was searched or back out.
Would seeing your body cam refresh your recollection and whether or not you patted him down and searched Mr. Avery?
Yes, ma'am.
Marking this as the exhibit B for purposes of identification. Permission to approach the witness, Your Honor.
Yes, it is proposed exhibit B.
Yes.
No change.
No. Is Your Honor even refreshing, Officer Newman?
No.
Would you like to rewatch that video again?
The video clip shows me detaining. I didn't see any search.
That's fine, we can move on. So let's talk about where the gun was actually found. Earlier you said you don't remember or you cannot recall whether or not Mr. Avery was working on a red car, correct?
You asked me specifically what color was the vehicle. I said I didn't recall the color.
Okay, seeing your body can refresh your recollection of the color of the car that Mr. Avery was standing in.
Right. Yes.
Permission to approach the witness with the same video. Your Honor. Yes.
Proposed exhibit B.
Yes. Yes, Your Honor. Your Honor, I'm having some issues with the video. Let's do it this way. The gun was found under a white Prius, correct?
I don't recall the model of the car. From the video that you showed me, it looked like a Grand Prix Pontiac.
Okay, so the gun was recovered underneath the Grand Prix, whatever, the car that you just seen in the video, correct?
Correct.
That car was not the car that Mr. Avery was standing near when you saw him when you were driving down the street, correct?
Correct.
That car was nowhere near Mr. Avery, correct?
That's where he walked towards.
That car was nowhere near where Mr. Avery was standing, correct? When you saw him.
Correct.
You're on routine patrol that morning, correct?
Correct.
So when you were driving down Marlowe Street that morning, that was the first time you drove down that street, correct?
Possibly.
You weren't watching the house the day before?
No.
You weren't there earlier that morning?
No.
So you don't know who was walking in and out of that house, correct?
Correct.
That house doesn't belong to Mr. Avery, correct?
I wouldn't know
That driveway isn't, the driveway where the gun was found isn't the driveway that belongs to the location of the incident that's located on that police report, correct?
Objection, Your Honor. House Response.
Your Honor, whether or not the property on whether or not the driveway on the property is speculative to whether or not it's located on the incident location is not speculative to the police officer that was there at the time.
Yeah, I'm going to overrule if he knows, he does. You know the answer?
I'm sorry.
He said correct.
Could you answer it, actually?
The driveway that the car where the gun was found is not the driveway that is connected to the address listed as the incident location.
Are you asking, just to, are you asking like the arrest location?
I'm asking about where the gun was found. It was found underneath a white car, that Grand Prix, correct?
Correct.
It was found, that Grand Prix was parked in the driveway, correct?
Correct.
That driveway does not belong to the location listed on the incident as 15861 Marlowe Street, Detroit, Michigan.
I'm not for sure.
You can move on. So you don't know who had access to the driveway?
Correct.
There were other people that were standing outside, correct?
Correct.
They weren't searched, correct?
Correct.
They were not detained.
Correct.
And their names weren't looked over on lien to make sure that those guns, to see if they were registered to them, correct?
Correct.
No further questions. Your Honor.
Redirect.
Briefly, Your Honor. Officer Newman, was your view of the defendant obstructed in the driver's seat in any way?
Like, was there a point that I couldn't see him?
Correct, from the driver's seat. Were you able to see him, or was there anything?
Briefly, the vehicle.
Briefly, the vehicle?
Yes.
And would you have been, because Mr. Avery was in the streets, would you have been paying attention to him operating?
Yes.
I have a question.
Yes, sir.
Was there testimony that he was ever in the street? Because I heard officers say that he was in the driveway. Can I clarify, Your Honor? They had both of you all there.
Yeah, so the arrest location was actually near the front porch of the house that's listed on the address on the complaint. But where according to Officer Newman's police report, Mr. Avery is standing in the middle of the street working on the car.
Was there testimony?
He did say that when he first saw me.
I didn't hear you say that he was in the street.
No, not in the middle of the street. I never said he was in the middle of the street. I said he was near the street by the driveway. That's what my regulation was.
I will let you be crossed on that.
And one final question for you, Officer Newman. What car was Mr. Avery nearest when he reached for his basement?
He was between the two vehicles. So no one else parked on the street and the one that was in the driveway.
like 50-50 between the two vehicles?
Possibly, yes.
No further questions, Your Honor.
In Attorney Garage, I would allow a recross based off of what I had.
Briefly, when you saw Mr. Avery near the car where you found the gun, you said Mr. Avery just walked between the two cars, correct?
Yes, Your Honor, correct.
The gun was found underneath the car, right?
Correct.
At no point in time did you see Mr. Avery bend over and under the car, correct?
I briefly lost sight of Mr. Avery.
Well, you testified on redirect that the time that you lost sight of him was while you were in your vehicle, correct?
Correct.
And at that moment in time, you had exited your car, correct?
I'm not understanding.
At that point in time, where you had recovered the gun, you said you had seen Mr. Avery walk around that car. You had already exited your squad car at that time.
You're asking me, did I exit my squad car before or after I seen him? I lost sight.
Before or after, you said that there was a brief obstruction
Correct.
of Mr. Avery, correct?
Correct.
Was that while you were seated in the squad car?
Yes.
Okay. And then at what point in time did you see Mr. Avery walk around the car? Were you outside of that squad car or in the squad car? So you were outside of the squad car. And at no point in time did you see Mr. Avery on the floor of that driveway, correct?
No, I've never seen him before.
You didn't see him under the hood of that car, correct? Where the gun was found.
Correct.
And the gun was found underneath the car, correct?
Correct.
All right, let's talk about the car that you saw Mr. Avery initially buy when you were driving down Marlow Street, okay?
Okay.
Now, that car was not parked in the driveway, correct?
Correct.
It was parked along the street.
Correct.
And the hood was open.
Correct.
And there were some tools out there laying around, correct?
Possible.
And you saw Mr. Avery standing in the street working on that car, correct?
Correct.
Yeah.
Thank you. No further questions.
No, redirect, Your Honor.
Okay. All right, so you're all set. Okay. Any other questions?
No further witnesses.
For defense?
No witnesses for the defense, Your Honor.
Whenever you're ready for argument. Okay.
People who can bind over on all of and reserve arguments.
Your Honor, at this moment in time, the defense counsel asked the court not bind over Mr. Avery on the charges, due to the fact that the government must prove that Mr. Avery as an element of the felon in possession and ammunition and firearms, that Mr. Avery was actually in control of the gun or had some kind of possession, purchased it. The prosecution has put forth no evidence to suggest this. There's been no evidence presented as preliminary examination, although be a low standard that Mr. Avery had any control over the gun, the firearm that was found in the driveway. There was no evidence to show that Mr. Avery had even constructed possession of the gun. There's no evidence to show that Mr. Avery purchased the gun. Mr. Avery was asked, does he have a gun registered to him by officers that were on that scene? And he said no. And the lien check also presents Mr. Avery does not have any firearms registered to him. Mere presence is not an indication of guilt. Mr. Avery was not near the gun at the time that the officers retrieved the gun. And the testimony by the officer today showed that there were other people that were also there outside. That house doesn't even belong to Mr. Avery. He doesn't sleep there. He doesn't sleep there. He doesn't know who is walking in and out of that house. The officer did say as well that they weren't watching that house, so they don't know who was also walking in and out of that house. And that driveway is doesn't even belong to the address of the arrest location. And there were other people outside at the time. So
Your Honor, mere presence is not an indication of guilt, and at this time, we ask that the court not bind over Mr. Avery on the charges.
The people's argument?
Yes, Your Honor. So while mere presence is not sufficient, we do have more than mere presence in this circumstance. Mr. Avery did go to that location after adjusting something presumably in his waistband, and then putting it under there. There were no other people standing anywhere near there prior to the officers actually approaching that vehicle and discovering that pistol underneath.
Okay, so testimony today from one witness, Officer Newman. Who testified that when he was on patrol in the area of 15861 Marlowe as the driver, after corrected by counsel, that he saw the defendant look at the patrol car and then walk away, saw the defendant reach from his waistband. He believed to be consistent with concealing, or hiding something. Saw the defendant walk on the other side of the vehicle. There were no other people near the vehicle where the gun was found. Officer believed that the defendant discarded what later was to be found as a handgun. I do believe that people have met probable cause standard to establish the 4 counts here. 1, possession by another, prove constructive possession. I do believe that the defendant had knowledge of the handgun under the car based off of the fact that the officer has provided to the court, as well as the ability to control that weapon at some point in a very short moment. For count 2, the weapon is felony firearm, count attached to count 1 to satisfied. And there's testimony that there were live rounds recovered from the firearms that satisfies count 3. And as well as count 4 was felony firearm charge attached to count 3. So Mr. I will have found that we were in custody. So it'll be 1 week from today. So April 25th at 9:00 a.m. at Frank Murphy Hall of Justice. Rearrange on information. I think I've asked this before, but is Mr. Avery already in custody on this case?
No, we haven't talked about this, Your Honor, and he had made me aware that the reason why he's in custody is not pursuant to this case.
Okay.
To the case.
Okay. I want to make sure.
Thank you.
Anything else?
Nothing.
Okay, we ready on Ms. Bennett?
I think it's on the way up.
Oh, okay.
Yes, sir.
Okay. The people of John Michigan versus Alexis Allison Bennett, 2260711. Ms. Bennett is charged with assault with dangerous weapons on assault, but here today on a tether violation. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Ms. Alexis Bennett, who's also appearing by Zoom in custody from the Wayne County Jail. Ms. Bennett, can you state your full name for the record, please?
Alexis Allison Bennett. And Attorney Cohen, the booking sheet, mediation report.
I did receive, yes, a 2-page report that does seem to describe the alleged violation of tether.
Okay, the people are reviewing it now. I'll give Ms. Parrish a moment to review it. It's my understanding that basically she didn't charge her tether. Is that?
I forgot my tether at Dickerson when I got picked up. All my belongings was at Dickerson still.
Okay.
And I was never able to get a ride back to Dickerson.
And I would also point out that Ms. Bennett was also hospitalized for a good chunk of that period between April 12th and April 17th.
Okay, what is your request, Attorney Cohen?
Well, Your Honor, the tether was placed on the very last day that the court previously essentially gave the county jail. So I was, a few hours away from petitioning the court to remove the tether entirely, but she was released again on that Friday. My request would be to, I guess I would renew my request for removal of the tether at this point and ask that Ms. Bennett simply be released on a personal bond. It does not appear that she violated in terms of going near any stay away zones or left the home. And again, this is an older case. I think it's about a year old at this point. In the alternative, I would ask that the court reinstate Ms. Bennett's bond and allow her to be released on tether so that she can be out during the pendency of this case. I know that we are set on May 10th for a PCC. If the court is not inclined to release Ms. Bennett, I would ask to accelerate the examination of this matter significantly.
Do you know why the PCC is set so far out?
Yes, Your Honor. It was because we were set originally, and I emailed the court indicating that Ms. Bennett had been hospitalized and requesting an adjournment. I was not sure of, whether she was competent at the time. I don't currently have any competency concerns. But it was also because I did not know how long she would be hospitalized. There was an indication she was going to be involuntarily hospitalized for a minimum of 10 days with the possibility of more, but that appears not to have panned out. I did not receive any updates from the hospital after I had spoken to the social worker several days ago.
Okay, so for scheduling purposes, I can move the PCC up to a closer date, and we can set an exam if you like. That date.
Yeah, that would make sense.
Okay, and I'll allow people to respond to the tether request.
Your Honor, I understand better now the defense's explanation. It would object to a personal bond. At this point, we're in a situation where the battery ran out. Neither myself nor defense can actually say where or what the defendant was doing at this time. That being, and as of right now, I think we need to get the defendant following the original bond orders charging the tether and staying on the tether. That being said, I do not wish to have the bond revoked or have her stay incarcerated. I believe that possibly this was just an error. That being said, though, because there was an error, I would not, the people would object to any lowering of the bond. However, we don't object to expediting the exam. And also, as we stated, having her released with the tether and back to the original bond agreement.
Okay, Attorney Cohen, do
Yes.
you have this on this case?
I'm sorry, what was the question?
Do you have discovery on this case?
I only have limited paper discovery, Your Honor. I believe there should be digital discovery, including body worn cameras, interviews of the complainant and potential eyewitnesses in this case, but I have not received any of that digital discovery yet.
Okay.
And I believe the people, and I'm pulling it up now, I do recall us originally, and I believe due to the fact that the charges are felonious assault, that we assumed, and just stating assumed, that there wasn't any digital, but nonetheless, we did reach out to an OIC asking for them to upload any. We do not have any yet. Mr. Cohen, if you want to reach out to me in the next 2 days, email me. That way I can follow up. If you don't have anything in those next 2 days, I will follow up once again with the OIC and hope to get an explanation as to why, since you do believe that there is some. And again, no objections to expediting the exam, possibly the first week in May.
Okay, Attorney Cohen, I provided some dates. Do any of those dates work for you?
Yes, Your Honor, I was just reviewing that. I can do May 3rd at 10 o'clock for an exam.
Okay. And do you want another PCC to discuss the digital discovery?
I don't think that's necessary, Your Honor. I can be in touch with Ms. Parrish, and then I'm trying to figure out or remember whether I filed a motion and got an order for discovery already. I believe I did. So we already have a signed order in place. I'll just keep coordinating with Ms. Parrish and we'll get what we can prior to the exam.
Okay, so for the tether request, she has not failed to appear. I am going to remove the tether simply because last time, well, first, she has not contacted the complaining witness. She hasn't violated any terms other than not charging it. She sat in custody for a very long time, waiting for a tether, and I believe that will happen again if I put the tether back on her, and I don't think she should be in custody for another week just because she's waiting for a tether. Ms. Bennett, I'm going to allow you to be released on a $10,000 personal bond. And of course, no contact with the complaining witness. You are not to, that means no contact via social media, text message, family members, friends, or any way whatsoever, or to the location of the complaining witness, if you know where that is. And there will be a curfew, 10 p.m. to 6 a.m. You are to be at home, even though you do not have, 10 p.m. to 6 a.m. You are to be at home, even though you do not have a tether. And your exam has been set for May 3rd, 10 o'clock in person at 36th District Court. So you are to come to 36th District, you're not on tether, so you have to do this on your own. You do not show up, there will be a CAFIAS, and the $10,000 will be what you have to post to be released from the Wayne County Jail. You understand that? Ms. Bennett? Actually, you're muted. I heard you, I saw you say yes, ma'am, but you have to be unmuted. Okay, well, the county jail said that she was done with her case. I saw her mom say yes, ma'am. So Attorney Cohen, can you make sure she's aware of her date, please, when she's out?
Yes, I will reach out to her and her support network and make sure that she's aware of that.
Okay. Anything else? Nothing.
Nothing from defense. Thank you, Your Honor.
You're welcome. Have a good day.
You too.
Can we handle the adjournment request by, for Damon Johnson? You can just stay right there.
Okay, run the record, this is people of the state of Michigan versus Damian Johnson, 2206-0507. Johnson is charged with one count of stolen property, receiving and concealing a motor vehicle, set today at 11 o'clock. Experiences?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Judge Lee, your staff, may I please this honorable court, distinguished by Davenport, number 82743. I'm presenting for the attorney of record, Curtis Davenport. However, Judge, I am asking for Mr. Johnson's presence to be waived for this request.
I will waive his presence.
No objections from people.
Okay. So what's going on?
Your Honor, we did resolve some issues. The people had originally asked for an adjournment due to two officers, one being at a training and the other one actually being on furlough until May 2nd. So we put in a request with the court and what we thought to be the defense attorney via email. Unfortunately, due to 36 system being down, we could not verify. However, this Davenport notified the court earlier, as well as us, that she is standing in for this this case on Mr. Davenport's behalf. So we are currently updating our system. And we will be providing because discovery was sent us, again, we didn't know this at the time that we asked for an adjournment. The discovery was obviously sent to the wrong counsel as well. So we will send discovery over to Ms. Shabazz Davenport today. And I believe there is no objection from defense, but we would like to set the preliminary exam for after May.
And because there's no objection, I have to make it available. I also do want to just ask that the ROA be corrected to reflect Attorney Curtis Davenport, entity number is 82678. I actually have been the only attorney present on this case. I've been saying my husband. So it's only been me, but it is Attorney Curtis Davenport as the attorney of record. So I would just ask the ROA to reflect that, but I have no objection to the adjournment request.
You said after May 3rd or May 2nd?
After May 2nd, yes, Your Honor.
Okay, so May 3rd, 4th, or 5th.
I'm available both May 3rd and May 5th.
Let's do May 3rd at 10 o'clock.
That is great for us.
And just for the record, the system is under maintenance. It's out of our control. It will not be up until SCAO, that's the Supreme Court Administrative Office, and all of the expungements have been completed. So we don't have any control over it until everyone's stuff has been moved and their criminal history has been.
That's fine, Judge. I'll continue to appear. I know that
Okay.
I will be here.
That's why you say exchange for. Okay, turn to what about Clarence Jack?
Yes, yes, I want to try to happen to this, my client is in the hallway and I'm going to be asked for this on this case. There's a circuit board, I see a little one earlier, but I still came down.
Okay, Attorney Simon, are you told? Oh, okay. All right, well, the good news is, okay, Attorney Shabazz, I guess I should say, Mr. Parrish, are you handling Clarence Jackson? No, ma'am. Okay. Okay, we're on the record. This is the people of the state of Michigan versus Clarence Jackson, 2355910. Mr. Jackson is charged with one count of carrying concealed weapon set for an exam today at 10:30 a.m. Clarence.
Morning, Your Honor. Daniela Parrish on behalf of the people of PA 5495 standing in for APA Kirker.
Good morning, again, Judge Julia, staff, and Senior Shabazz, that of court, appearing on behalf of Mr. Clarence Jackson, who was also present in the courtroom. With pleasure, Mr. Martin.
Good morning. Okay, Attorney Shabazz.
Judge, thank you. Thank you, Judge, I appreciate it. We're here today for an examination, and we were before this court on April, it appears to be April 3rd, which is more than 2 weeks ago. I did have a discovery order signed by the court. It was a wet signature, but I actually appeared on the record first, made a very distinct record, asking exactly what it was that I was looking for with regard to discovery. I have only partial discovery, which would include only one officer's body worn camera and digital dash cam and install car video. I did make a request for all of the remaining officers' body worn cameras and the scout car video. There are 2 officers in the hallway right now who I did speak with. Both of them did indicate they actually did have on body worn cameras, and they did actually upload the body worn cameras. I do have an officer in charge also in the courtroom, who I just spoke with, who indicated, I guess, the procedure for uploading the body worn camera. However, Judge, it appears that there has not been any further action with regard to the court's direct order to produce a discovery. I have been in communication with APA Paris, who did actually send over the discovery request to the officer in charge. From there, Judge, I have received no further discovery. It is critical to my client's case for the examination stage precisely, Judge. So I would ask for a dismissal for failure to produce the discovery that was requested as a direct order of the court, as also for the 14th Amendment due process and equal protection of the law. My client actually has the right to have his examination within 7 days. We have been well over 7 days.
Yes, Your Honor. We would object to a dismissal, and we would determine if indeed everything the defense, and I believe that she has been forthcoming and communication with everyone. The officer in charge is here to my left, and she can also indicate to the court her efforts. But as indicated, if attempts were made by the officer in charge to upload additional digital discovery, and was unable to do so, would indicate that the people would just further confirm people do not have any additional at this time to provide. We are happy to, and that's why we would request an adjournment, since defense indicates that it is integral to their defense. We do want them to have everything that is out there. If there is additional, that's why I brought the OIC to speak to the court. If there is additional, we are in the belief that she will continue to attempt to obtain and upload it. Again, it has not been uploaded at this time, has not been verified to us. And as defense indicated, she has spoke to the OIC and detailed exactly what they are looking for. This officer in charge here to my left, if you would like to ask her any further questions in regards to the matter.
We were on the third for the exact reasons that we wouldn't be here today to have to even entertain the journey. So does the discovery exist that Attorney Davenport is speaking of?
I did not, I was not aware that they did, but according to the officer in charge, could you state your name, please?
Yes, Officer Willis, 2399. Good morning.
Officer Willis, is there additional discovery pertaining to this case that the defense counsel is requesting?
At this time, to my knowledge, I have double checked, and the video that was provided was the only video at the time.
I would ask when exactly was it checked, because I just spoke with 2 officers in the hallway, and there are 2 separate bodies, and they both indicated they did have body worn cameras. So I would ask exactly when was the check, because I heard at this time. So I would ask what effort and when.
With this work was typed, and also back when I received an email, I don't know the date offhand, but we will go back and double check the email, and if that time there is no extra reminder, please. It's really nothing.
So usually my main concern is always discovery that exists that is not provided. So if there are officers in the hallway that say they have body cams that would be relevant to this case, I need to understand if that's.
Your Honor, may I've been on other cases where officers have indicated, just because they have body worn camera on does not mean that the video was actually, taken or recorded. And officers, it is not, to my understanding, the officer in charge, correct me if I'm wrong, but they are not the ones who upload the video. They do not know if the actual video, all they can attest to is if they actually had body worn camera on. So it would be inappropriate for them to tell me or in defense, whether there is video, because they, on numerous occasions have told me that they don't deal with that. So
I don't think it's inappropriate. It may not be helpful.
well, they don't know because they don't deal with it. They just know if they have body worn camera on. They can't actually indicate what happens.
It's
The
even
moment
more
the
of a
video is
problem.
actually on or not on, or uploaded or not uploaded.
It's even worse if they have body cam on and they believe to be recording and it doesn't exist.
I want to even go even further. There's only 2 of at least 6 officers that were actually present at my client's home during this arrest. So that's only 2 officers, but at least I only got 1 body worn camera.
Does the discovery, where are you learning that there's other digital?
Paper discovery, Judge, and also the video that I actually do have, it actually showed the other officers with their uniform with the body worn camera, which is why I actually did the discovery order. And I don't believe it's enough to just say I checked what exactly were the attempts, because I've had cases as well where the officer in charge checked, but then after they have the discovery order, then they actually go back and precisely check for each actual officer, and then they produce a discovery. That's what the discovery order was for. I'm gonna be very clear, just my client, he was arrested on about, in March 10th. I was before Judge Robbins on March 20th, where I also had placed it on a record for the request for the discovery. I appeared before this court on April 3rd. So the officer in charge had plenty of time to actually check for all of the discovery. And also, I don't have a burden to tell the officer in charge to produce this discovery. That's the people's burden already.
Did you receive, Officer Willis? Yes. Did you receive a discovery order? I am not sure about this case, but I know when we do receive them, or speak for myself, when I do receive them, I go back and check. Each officer, if they may have body camera, may not, like we stated before, sometimes it doesn't upload properly in our system, sometimes it takes longer. So when we receive the email, we do go back and check. I know I do.
It sounds like officer in charge is speaking as far as just in general, but we're asking specifically in this case, because you just actually asked if she had a discovery order, and she said she don't know specifically on this case, but we know that there was a discovery order that was signed, and I've been actually very zealous on this case. I even sent an email to the court, letting the court know that I still did not have discovery, and I also even appeared on Zoom this morning. I don't want to babysit the officer in charge, and I don't want to try to harass them, but this discovery has been integral, and I stated that at the initiation of this case. So I'm not asking for an adjournment because my client had a right to have this exam way before.
Sure. My question is, does any other discovery exist?
Your Honor, when I checked prior, what I provided there, if there was more, it is not somebody knowledge.
Sounds like I don't know, which is, I don't believe sufficient.
Your Honor, and that's another reason why people just not completely understand what defense is saying, but because
I'm tired of adjourning for discovery, because she came in on the 3rd so that we would not have to do that today. We could have had someone else in this slot. We're 2 weeks behind because of adjournment and things of this nature.
Well, I'll defer to Your Honor on this. I don't disagree with the court on that matter. If that is the case, we just ask that it's without prejudice, allowing the OIC to reissue the charges.
Ms. Perry, does it say in the discovery that there's body footage or camera footage of more than one officer?
It just says body worn camera, Your Honor. So I wasn't sure which officer she was, because she indicated that additional officers came. So I thought that's what we were looking for, additional officers aside from the officers that were on the scene.
Oh, no, I'm looking for all of the officers that were on the scene, and I did place that on the record, just, and that was at least 3 scout cars, and it appeared to be 6 officers, and that's just based off of the video that I did watch from the officer that I actually do have. But I spoke to 2 officers who both said they did have body worn cameras, and I don't know about the rest of the procedure, but I don't have to. That's for the officer in charge to do their job.
So the investigator's report does not state specifically who has body camera?
We're double checking now.
Okay.
Your Honor, right now, what it's indicating is audio and video appear to be functional. That's what their report is saying on each, on the report. Now,
And I want to also place on the record, but I also requested green light videos because paper discovery, which I placed on the record back on April 3rd, it did indicate also that there was green light video or location of the gas station. And so the officer in charge said, project green light location, officer in charge is supposed to go and get that also. You can't just sit from the computer and just say what's present at the time. I mean,
Your Honor, I don't know if that's actually correct, and if you can state where that is required. There, you know, in an officer's investigation, yes, you know, obviously, the people like to have every bit of evidence we possibly can going into a trial. But if an officer doesn't go and maybe interview a certain person or go to a certain person's house and get the video, just because there is that video, if they didn't go and obtain it, they don't have it, and it's not going to be used against the defendant. I understand what they're saying, but again, if the police officer in their investigation didn't go and ask for the green light or didn't go and ask for a rig camera or something, I don't believe that that falls into the purview of the discovery order, because they didn't obtain it. It's not evidence that's going to be used against them in this court. If it's something that they want to go and get that on their own, if it's going to assist them, I completely understand, but it's not discoverable because it wasn't actually used in the case at all in the investigation, in the charging documents. So I don't know if stating it's a green light area or a green light location, it's not like the IR says in there was green light video, we obtained green light video. It does not say that.
I'm trying to just get verification of what the investigative report says as to what this agreed.
And I'm looking over APA Kirker's back as he's looking on there, and it's just saying that it is a project green light location. It does not state, Your Honor, that they obtained the video, anything of that nature. Not even the video was review of the green light, just as a green light location.
and I'm not even gonna respond to that because I'm pretty sure the court is aware of how green light videos go and when.
It's under surveillance by Detroit Police Department, right? This is at a green light location. The incident?
Yes, Your Honor. Exxon gas station.
And that was placed in the report also.
What was placed?
On the green light video, on the place for the green light video, in addition to the body worn cameras. And don't sound like there were any attempts to go back to the green light.
The request for the green light video was in the discovery report?
Oh, yeah, yes.
All right. So I'm going to dismiss without prejudice. People, Mr. Jackson may likely reissue this case once they provide certain videos, green light video, it can exist. But, it seems to me that everyone's in here, the lawyers are officers of the court, and there seems to be other body cams that is not produced, or I don't have clarity as to whether it exists. It's not, I'm not getting a clear answer here. So, and there was a request on April 3rd, very specific, as to be provided, and nothing was provided. So, this the green light place. Did you receive a response as to whether the green light video existed from the discovery order? Okay. Okay. All right, so I'm going to submit without prejudice, and the people who need to be issued, if need be. Thank you, Judge.
Thank you, Your Honor.
Well, take care. Okay, now to Mr. Durham.
Judge. At 12 o'clock summer. This was online. This was a 10 o'clock exam.
Started at 8. We were on time.
I understand. No, you were on the bench when I got here.
Yeah.
It's not. Problem is, I have someplace else to be. What I would like to perhaps review with Mr. Durham, and they give you take the exam.
We're here. We have a lot of things to appear on here.
Well, I think the last 90 days have given us a lot of time to think about the necessity to appear in court as a director at time.
I'll probably get you to this one. Mr. Kirker, is everyone here?
Yes, for both cases.
They're all officers? Yep. Okay, well, on the record is the people of the state of Michigan versus Carlos Lorenzo Durham, case 2258771. In this case, Mr. Durham is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, firearms, count 3, weapons, ammunition, possession by a felon, count 4, weapons, firearm, count 5, weapons carrying concealed, count 6, police officer assault to resisting and obstructing with a provincial offender force, notice. Also, Mr. Durham is charged on case 2259974 with 1 count of police officer assault to resisting and obstructing with a provincial offender force. Just notice both set for a preliminary examination today, 10 o'clock.
Alexander Kirker on behalf of the people, P86282.
Jonathan Simon, P35596 on behalf of Mr. Durham.
Can you state your name, please?
I think my name is spelled the wrong way on your paperwork. Can I spell it correct?
Yes.
My name is all lowercase CARLOS, Carlos, all lowercase NARENZO, Lorenzo, all lowercase BURHAN.
Okay.
I'm not claiming to be the all cash name that they have in their paperwork.
Okay. Thank you for that.
Your Honor, Mr. Durham isn't, well, perhaps we should first address the examination issue. The matter was set for 10 o'clock. I was here well before, and I know the court was too, and Mr. Kirker. But due to docket congestion, it is now 11:30, and we have not yet begun. And I have a 12 o'clock seminar discovery, for which I have registered, received 1.5 CLE units. What I would like to do, if I could, is address Mr. Durham's bond, and perhaps if the court would consider allowing him to be released, then perhaps you could rename the examination.
Okay.
Your Honor, initially, I think there had been a caveus. I think that's how I got the case. But I know that since I've had the case, there were some changes back when Judge Williams had the matter, and the dates were changed. And I think that sort of contributed to a little bit of confusion, which led to, I think, the more recent caveus. However, when that habeas occurred, both cases reached that $10,000 cash bond. And normally when the habeas are set aside by the magistrate, personal bond or a very reasonable bond is set, but that didn't happen here. The $10,000 cash bonds were carried over and are still in existence to this day. In January, when the matter did come up before the court, at that time, we had requested a forensic evaluation. Mr. Durbin has been found to be competent, and he is before your honor. However, he has now accumulated since I think January, approximately 90 days of credit, which I think is probably a lot more than the outcome of this case would probably dictate. I think he knows and understands the importance of appearing on time and as directed. And we will maintain closer communication to make sure that he is aware and is able to attend all future proceedings. We would respectfully submit that a case of this nature. I understand there's a felony firearm. And we understand the mandatory nature of that. However, my experience, a lot of those are being resolved in a different manner, which does not require them otherwise mandatory 2 years. I think that Mr. Durbin has every reason to appear and no reason not to. And we submit that under the circumstances of the personal bond on each matter.
I will address the adjournment request. Mr. Kirker, I know that the people are ready to proceed. What was ready to go at 8:30. The docket, there was a delay here. I do not want to penalize the defendant for attorney signing for something that's out of control. I want to grant adjournment. Is against your objection?
Yes, Your Honor, the people have no objection. We had one of the officers in this case has somewhere else to be.
Want to call the officers in so we can grant a date?
I can do
Officers on Durham.
May 3rd, 4th, and 5th. On the 4th and 5th, you can use first exam.
Fourth is good all morning, fifth is good all day.
Okay. Good morning to all the officers. So I have to adjourn these cases. I want to bring you all in to get dates to see if you all will be available for the adjourn date. So we're right now discussing May 4th and May 5th in the morning, 9 o'clock. Conflict? No. So May 4th at 9 o'clock? Okay, thank you for your patience and understanding. And as far as bond, do you have a response?
Your Honor, our concern would be with both the initial or the defense notice and the past cases. We would press the bond.
I will adjust your bond. You're in the Wayne County Jail for a very long time for this matter. Today, it's not your fault. And there are no civilian complaining witnesses on these cases. I am going to lease you on a personal bond. It will be $10,000 personal. I am going to impose the test, however. Okay. And were you employed before you were incarcerated?
I work for myself. Will
Will you be able to work after you're released?
Yes.
Okay.
As long as I get out, I work.
What type of work?
Do home improvements, electrical plumbing, stuff like that.
Okay.
I actually worked on my sister's house. The Detroit police took the car to drive.
So I will just put curfew of 10 p.m. to 6 a.m. You're supposed to be in the house. You have stable housing?
Yeah.
Let me take this off YouTube. Everyone is
Yes,
there.
ma'am.
Okay. You're welcome.
Yes.
All right. Judge, I just looked at this, okay. This is the people of the state of Michigan versus Adam Michael Carrington, 2355996. Mr. Carrington is charged with 1 count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 2, which is a misdemeanor, operating a license suspended, revoked, and or denied, set for preliminary examination today. Harrison?
Running Your Honor, Daniela Parrish on behalf of people P85495.
Good morning, Your Honor, Veronica Walrad with NDS P85665 on behalf of Mr. Carrington, who is present in the courtroom. Mr. Carrington, if you can state your name.
Adam Carrington.
Is everyone ready?
Your Honor, my apologies. People are unable to proceed at this time. I would state that officers have failed to appear. However, after further investigation on my part, subpoenas actually were not sent out. I know that this case was, preliminary exam was set on the 3rd. I believe that Madam Clerk set the exam date for us. I actually have no excuse. It just fell through the cracks, Your Honor. And I have no idea whether it was myself or anyone else, but I'll take full responsibility. And subpoenas weren't set out. So normally, the people would ask for an adjournment in order to not have to reissue. But of course, I understand the reasoning is not really valid, so I will use discretion.
Your Honor, Honor, at this point, the defense is prepared to proceed. It's been about 2 weeks since the PCC. So there was time to subpoena the officers. I would go to dismiss.
I would recommend dismissal, be dismissed without prejudice. Mr. Barrington, just so you understand, your case is dismissed today because the people are not ready to proceed. But dismissing without prejudice means that the people may reissue the case. You'll get notification of that. But as of now, your case has been dismissed. Okay? So you can have a seat in the hallway, and you'll get a dismissal form. And then you're free to go.
Okay, thank you.
And we're off the record.